out of the Southern District of New York, a bunch of publishers: Penguin Random House, Simon and Schuster, Truman Capote, Jack Kerouac, Hemingway, Arthur C. Clarke, have sued Frederick Colting and Melissa Medina, doing business as Moppet Books. And Judge Jed S. Rakoff, who I think is a pretty famous judge who has done one or two things with, I forget, maybe Brandon can look that up for the end of this, has ruled that what they're doing with these books is not a fair use. And so I thought we would go over his opinion here, and we'll see why. On January 19th, plaintiffs, all of them, alleged 9 counts of copyright infringement against Frederick Colting and Melissa Medina. Plaintiffs are owners of the exclusive licenses to copyrights in 4 famous novels: Breakfast at Tiffany's, Old Man and the Sea, On the Road, and 2001: A Space Odyssey. Defendants have published a series of illustrated children's books based on these novels, called the Guides, which contain condensed, simplified versions of their plots. So I'm going to compare it to Cliff Notes. Thrift Notes? Where did that come from? To Cliff Notes. I haven't seen, I don't know how similar they are to Cliff Notes, but let's just assume that these were unlicensed, condensed, simplified versions similar to Cliff Notes. Following the completion of discovery, plaintiffs sought summary judgment. In a bottom line order dated July 28th, the court granted summary judgments on all 9 counts, 2 for each of the 4 novels and 1 for the character of Holly Golightly, and rejected the affirmative defense of fair use as a matter of law. On the issue of willfulness, the court permitted defendants, based on representations made by their counsel, to raise defenses and additional discovery on that defense. As a consequence of that decision, plaintiffs no longer seek summary judgment on the issue of willfulness, and the court has set the case down for trial to resolve the remaining issues. This order sets forth the reasons. The pertinent facts, either undisputed or were disputed and taken most favorably to the respective non-movement, are as follows. Plaintiffs own valid copyrights to Breakfast at Tiffany's, Old Man and the Sea, On the Road, and 2001: A Space Odyssey. The defendants' colorfully illustrated story summaries called KinderGuides are designed to introduce these works to children. On or about September 22, 2016, defendants published their 4 guides. On their front covers, the guides very prominently display the titles of plaintiffs' novels and the names of their authors, along with the words KinderGuides in large print. Early Learning Guides to Culture Classics in smaller print. The only other words are illustrations by blank, containing the name of the author in small print at the bottom. The guides share the same layout. The first 4 pages feature illustrations and one-line quotations taken from and attributed to the authors of the novels. The 5th page contains publication information. The 6th is a title page. KinderGuides, Early Learning Guides to Culture Classics, On the Road, by Jack Kerouac. Illustrations by Rose Forshall. A division of Moppet Books, Los Angeles, California. The 6th and 8th pages contain a table of contents. The 9 is an illustration of the original author. The 10th is a page about the author. The following these are short summaries which comprise a few dozen pages. Appended after these short summaries are a series of back pages, 2 devoted to main characters, keywords, quiz questions, and analyses. Defendants admit that they had access to plaintiffs' novels in preparing their guides. This is part of copyright law, that you have access and that your work was substantially similar. Indeed, a side-by-side comparison of the plaintiffs' and defendants' works reveals as much. Not only do the plot, settings, characters of the guides mirror the novels, but the guides include many specific details. For example, Holly Golightly's business card reads, Holly Golightly Traveling. And in both versions, Holly describes an experience she calls the mean reds, or feeling afraid, but you don't know of what you're afraid. He goes on to quote further. It is also undisputed that there is an established market for children's books based on adult novels, and that it is not unusual for copyright holders to publish or license children's versions of works originally intended for adults, noting that defendant Colting understood prior to publishing the KinderGuides that there was a market for children's editions of adult novels. Defendants, however, never sought permission to prepare children's guides for plaintiffs' novels. It is further undisputed that plaintiffs have never authorized anyone to publish children's versions of their novels. The managers of Hemingway's literary estate altogether rejected requests to create children's versions of The Old Man and the Sea. Penguin is considering a version of 2001, but is currently against it. Capote Estate did authorize an illustrated standalone version of A Christmas Memory, but did not authorize Breakfast at Tiffany's. Finally, Penguin, Random House, and the Clark Estate have authorized the creation of English as a second language version of 2001, but no children's versions. When parties cross-move for summary judgment, the court analyzes the motions separately, in each case construing the evidence in the light most favorable to the non-moving party. Summary judgment is appropriate only if the moving party shows there is no genuine issue of material fact and that the moving party is entitled to judgment as a matter of law. The court must draw all reasonable inferences and resolve all ambiguities in favor of the non-moving party. The Copyright Act of 1976 grants copyright owners a bundle of exclusive rights, including the right to reproduce, to prepare derivative works. Plaintiffs allege that defendants' guide infringes on both of these rights. To prevail, plaintiffs must prove that they own a valid copyright, that defendants have either actually copied their works, and that defendants' copying is illegal because of a substantial similarity between defendants' works and the protectable elements of their copyrighted work. To prevail on the second ground, plaintiffs must prove that defendants' works are unauthorized derivatives. I'm going to skip the valid ownership part. I'm assuming that they have a valid copyright. Having therefore carried their burden with respect to ownership, plaintiffs must next show their work was actually copied. They can show this by direct evidence or by indirect evidence, including access to the copyrighted work and substantial similarity. The question of actual copying is distinct from and precedes the question of infringement and substantial similarity. To prove actual copying, however, plaintiffs need only show probative similarity, that the creators of the allegedly infringing works drew from the copyrighted works. Here, the undisputed facts easily establish actual copying. Defendants admit that in preparing their guides, they read plaintiffs' novels. They display the actual titles of plaintiffs' novels on the front of their guides and concede that their guides are based on the novels. This constitutes actual copying as a matter of law. It would be absurd to suggest that actual copying did not occur in a case where defendant's work is devoted to telling a large portion of the story of plaintiff's work. Substantial similarity. I'm going to skip this because we want to get to the fair use part. To avoid, therefore, this obvious similarity, defendants would have the court, in effect, subtract the defendant's guides from defendant's guides the characters, plots, and setting that were directly lifted from plaintiff's novels on the ground that these elements do not constitute protectable expression, noting that a court must limit its infringement inquiry to whether the protectable elements standing alone are substantially similar. Defendants make several arguments in support of this approach. First, defendants claim that the characters, plots, and settings in plaintiffs' novels are merely a collection of made-up facts or fictional facts, and since, historically or independently, facts are not protected, these elements are not as an aspect of an author's original expression. Are you kidding me? You're really trying to say that a work of fiction is rather a collection of made-up facts that does not warrant copyright protection? I'm sorry, I've seen some BS. That's pretty big BS. As defendants put it, their guide to 2001: A Space Odyssey merely summarized the facts of the book and the characters, not the creative expression that makes Dr. David Bowman and Hal, the characters, memorable. Defendants, in other words, the aspect of plaintiff's novels appear that appear in defendants' guides, such that the character of Holly Golightly, her place of residence, her trips to the prison, her relationship with Sally Tomato, are not protected expression, but according to defendants, fictional facts. This exercise in sophistry, however, which confuses the difference between historical or independently existing facts and fictional details created by a novelist, finds no support in applicable law, as the Second Circuit has clearly stated characters and events that spring from the imagination of authors are copyrightable creative expression. I really can't believe the judge has to go over this. Thus, the Copyright Act protects the literal text describing, for example, Dr. Bowman and Hal and the made-up facts about Dr. Bowman and Hal. Quote, unlike the facts in a phone book, which do not owe their origin to an act of authorship, each fact in defendant's guide is really a fictitious expression created by plaintiff's authors. Wow.
You forgot to change your scene, Leonard.
That's okay. We will change the scene now. Second, defendants argue that the characters in plaintiff's works are unprotectable stock characters, for example. Breakfast at Tiffany's is, according to the defendants, just the story of a small-town girl with a tough past who has come to the big city. Dean in On the Road is just a stereotypical womanizing wild guy, and Sal, our narrator, is portrayed as a young writer. Thus, defendants argue Sal and Dean are simply stock characters that do not warrant copyright protection. Defendants again misstate the law. While copyright law does not protect basic characters and stock figures, copyright law does protect characters who are sufficiently delineated to be original. As the Seventh Circuit points out, in the very case defendants cite, a knowledgeable old wino is not a copyrightable character per se, but one named Cogliostro, with an obviously phony title of Count, and faintly mosaic facial features, is protected. No more is required for a character copyright. Finding that Wonder Woman, a superhero with only superficial differences from Superman, is infringing, even though both are drawn from the same basic Herculean character type. Excuse me, not Wonder Woman. I misread. Wonder Man. Wonder Man, a superhero with only superficial differences from Superman, is infringing, even though both are drawn from the basic Herculean character type. The general rule is that where defendants' works use more than general types and ideas and have appropriated the pictorial and literary details, works are infringing. Here, defendants do not even attempt to conceal their copying. Third, defendants argue in the latter regard that the plots of plaintiffs' novels, which defendants reproduce in their guides, are unprotectable scènes faire, or incidents, characters, or settings which are, as a practical matter, indispensable or at least standard in the treatment of a given topic. So, for example, you can't copyright talking head videos. You can copyright a talking head video in which you did other stuff, but you can't copyright the concept of talking head videos. Or, for example, defendants argue that The Old Man and the Sea is a classic man versus nature story for which a trip in nature, the struggle against the fish, reflecting on nature, triumph, and defeat are unprotected. 2001, defendants say, is simply a man versus technology plot. On defendants' absurd theory, the plot of Don Quixote is simply Cervantes' hackneyed version of the Odyssey. Defendants totally ignore the well-developed distinction that while general plot ideas are not copyrightable, specific ones are. Defendants' guides do not tell stories that share similar plot elements with plaintiffs' works. They retell, in an abridged fashion, the very same stories, including the very same characters, incidents, settings, and plot twists as the original novels. To be sure, they do not copy every single incident, but it is well established that no plagiarist can excuse the wrong by showing how much of his work he did not pirate. Nor need a work create the same feel or effect as the copyrighted work to be infringing. By any reasonable comparison, defendants' guides copy substantial aspects of the themes, characters, plots, sequencing, pace, and settings of plaintiffs' novels. Indeed, that is their stated purpose. And derivative works. Plaintiffs also allege that defendants' guides violate their right to control the preparation of derivative works. The Copyright Act defines a derivative work as a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work is not derivative, however, simply because it is based on the pre-existing works. Only works that are recast, transformed, or adapted into another medium, mode, or language while still representing the original work are derivative. For example, book reviews and parodies are not derivative despite being based on and potentially reproducing substantial amounts of protected expression. That's a great sentence. That's Campbell v. Acuff Rose Music, one of the famous copyright cases from the Supreme Court, 1994. That case stated the general rule that the market for potential derivative uses includes only those that creators of original works would, in general, develop or license others to develop. So they wouldn't license someone to make a critical work, or in general would not license. So that does not count as a derivative work, even though it is based upon. Depending on its nature, a guide may or may not qualify as a derivative work. The issue turns on whether the guide changes the copyrighted material in such a way that the guide is no longer representing the original work of authorship. For example, the Second Circuit found that a guide to the TV show Twin Peaks, which merely transformed the original work from one medium to another, was a derivative work, but an encyclopedia based on the Harry Potter world, which did not tell the same story, was not a derivative work. By condensing, synthesizing, and reorganize the pre-existing material in an A to Z reference guide, the lexicon does not recast the material in another medium to retell the story of Harry Potter, but instead gives the copyrighted material another purpose. That purpose is to give the reader a ready understanding of individual elements in the elaborate world of Harry Potter that appear in voluminous and diverse sources. Here, though defendants' guides add additional material at the end, specifically a few brief pages of analysis and quiz questions, and information about the author, they are primarily dedicated to retelling plaintiffs' stories. 2 pages of analysis do not convert the guides overall, which are largely composed of story summaries, into something that no longer represents the original work of authorship. Like a translation, dramatization, or motion picture adaptation, defendants' works basically retell the story of plaintiffs' works in another medium. Because defendants never received permission from plaintiffs to produce their guides, the guides are unauthorized derivatives as a matter of law. And finally, to fair use. Defendants argue that, even if they have infringed plaintiffs' novels, defendants' guides are protected by the doctrine of fair use. Fair use is an affirmative defense to infringement traditionally defined as a privilege in others than... I don't like this sentence, but traditionally defined as a privilege in others than the owner of the copyright to use the copyrighted material in a reasonable manner without his consent. I prefer to see fair use as a right from the Ninth Circuit's case. Was it Ninth Circuit? In Lentz v. Universal. Though a fair use is a mixed question of law, in fact, where a court finds no genuine issues of material fact, it may conclude as a matter of law that the challenged use does not qualify for fair use protection. The mere fact that a determination of the fair use question requires an examination of the specific facts of each case does not necessarily mean that each case involving fair use, there are factual issues to be tried. The Copyright Act specifically specifies 4 non-exclusive factors that bear on fair use. 1, the purpose and character of the use. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market for or value of the copyrighted work. These factors are not meant to be treated in isolation. They are designed to be weighed together. The doctrine of fair use furthers these goals by permitting others to use existing works in ways that their owners would not ordinarily use them. What fair use law does not protect is the right of others to produce works that, generally speaking, the creators of imaginative works might choose to produce themselves. Congress granted the exclusive right to produce or license such derivatives and others substantially similar works to copyright holders, regardless of whether, in any given instance, the copyright holders intended to use these rights or not. The central question presented in this case, then, is whether illustrated children's guides to adult novels are the sort of use that Congress reserved to copyright holders or the sort of use, like criticism or parody, which Congress intended to allow others to exploit. The first factor in a fair use inquiry is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. The work that adds further purposes or different character, altering the fact with new expression, meaning, or message, is often described in case law as transformative. Transformation in this sense has a particular meaning. As Judge Laval explains it, a work is transformative if it is productive, if it adds new insights and new understandings, seeks out new life and new civilizations, and boldly goes where if it adds new insights and understandings for the enrichment of society. Transformative uses of a copyright work may include, for example, criticizing the work, exposing the character of the original author, proving a fact, or summarizing an idea argued in the original in order to defend or rebut it. Here, defendants argue that their guides are potentially transformative in three respects. They abridge plaintiffs' novels, they modify plaintiffs' novels for a younger audience, and they add to plaintiffs' novels a page or two of analysis. None of these alterations are sufficient to sustain defendants' fair use claim. As an initial matter, U.S. law no longer protects abridgments as fair use, even in cases where the shortening involves, as Justice Story put it, real substantial condensation of the materials and intellectual labor and judgment bestowed thereon, and not merely the facile use of scissors. Instead, under the Copyright Act, abridgments are generally considered to be derivative works, and the right to prepare them is reserved exclusively to the copyright holder. See the Twin Peaks case. With respect to modifying the novels for a younger audience, the mere removal of adult themes does not meaningfully recast the work any more than an airline's editing of R-rated films so that they can be shown to children on a flight absolve the airline from paying a royalty. As Judge Laval puts it, the question is whether the work produces new insights and understandings. Here, defendants expurgated, I have never seen this word before. Expurgated guides are a vehicle for conveying to children the novel's original stories and insights. Indeed, it is quite clear that defendants' guides seek to fairly represent the original work of authorship. Defendants admit as such. Finally, there is the question of whether defendants' guides qualify as educational criticism or commentary. Works of criticism and commentary provide the sort of new insights and understandings that are the sine qua non of transformative use. Defendants suggest that their guides should be considered commentary. As evidence, defendants point to the few pages of analysis, but tacking on these few pages does not provide a safe harbor for an otherwise infringing work. The law is clear that, to be considered transformative criticism, the aspects of a work that reproduce another's protected expression must be in service of commentary on that work. Indeed, it is not enough for part of a work to have transformative purpose. Courts must also consider whether the work does so, transforms, to an insignificant or substantial extent. If a defendant's work describes the plot of a copyrighted work briefly in order to add significant comment about the author's plotting technique, then it's protected fair use. But if a defendant copies more than is necessary to facilitate comment or criticism, then it will not be protected. Here, defendants' story summaries do not recount plaintiffs' novels in the service of literary analysis. They provide literary analysis in the service of trying to make the guides qualify for fair use. Indeed, the defendants admitted this in open court when their counsel explained that Colting and Medina went to great lengths to achieve fair use protection. The very fact that we have these sections in the books, the main characters and keywords and analysis section, these things were all done to make these books fair use, at least in the mind of the defendants. Fair use, however, is not a jacket to be worn over an otherwise infringing outfit. One cannot add a bit of commentary to convert an unauthorized derivative work into protectable expression. Thus, defendants' guides do not transform plaintiffs' novels in a legally cognizable way. For this reason, and because defendants' guides are of a commercial nature, the first factor strongly favors plaintiffs. The second factor of a fair use inquiry is the nature of the copyrighted work. Expressly creative works tend to receive more robust copyright protection than news broadcasts or nonfiction publications. In this case, plaintiffs' novels are precisely the sort of creative works, thus the second factor favors plaintiffs. Amount and substantiality. The third factor, the amount and substantiality of the portion of the copyrighted work used, must be examined in context. This is not, as defendants conceive of it, a question of bare percentages. Instead, it turns on whether the extent of the copying is consistent with or more than necessary to further the purpose and character of the use. In cases of parody journalism and criticism, fair use doctrine allows for more of a copyrighted work to be copied where the purpose is less transformative. The question here is whether and to what extent defendants' copying was necessary to serve some transformative purpose. The answer is clear. Nearly all of defendants' guides are devoted to telling plaintiffs' copyrighted stories, with only 2 pages devoting to analyze them. Thus, the third factor favors plaintiffs. Effect on the use on the potential market. The fourth factor is the effect of the use on the potential market or the value of the copyrighted work. Under current law, plaintiffs need not show that their novels have suffered an actual drop in sales. To negate fair use, one need only show that if the challenged use should become widespread, it would adversely affect the potential market for the copyrighted work. And because the licensing of derivatives is an important economic incentive to the creation of the originals, this analysis must not only consider the effect on the defendant's guides upon the market for plaintiff's original, but also the effect of the guides on the potential market for derivative works. Defendants make 2 arguments in support of their contention that the fourth factor weighs in their favor. First, they argue that their guides do not affect the market for plaintiff's novels. To pretend that any consumer would go to a bookstore seeking one of the great American classics and instead choose to purchase an illustrated children's book defies belief. But it is defendants' burden to show that their works will not adversely affect either the market for the originals or for the derivative works. Both sides agree that there is an established market for derivative works as children versions of adult novels, and that publishers often choose to license their works to exploit that market. Indeed, plaintiffs provide many examples for the record of publishers exploiting this market in this way. Defendants also argue that plaintiffs have never created, marketed, or licensed any work that remotely resembles defendants' works. But even if this were true, it would not be enough for defendants to show that plaintiffs have not exploited a derivative market. It suffices as a matter of law that plaintiffs might change their mind. If the defendant's work adversely affects the value of any of the rights in copyright in the copyrighted work, the use is not fair. Thus, children's books fall into a market niche that plaintiff would in general develop or license, the fourth factor favors plaintiffs. The court will also take into consideration other factors that might bear on the question of fair use. Among these is whether, as defendant argues, their works should be protected because otherwise the constitutional purpose of copyright law would be frustrated. The constitutional purpose is to protect the progress of science and useful arts. As defendants point out, copyright law is designed to motivate the creative activity of authors. This monopoly created by copyright rewards the individual author to benefit the public. Thus, defendants ask the court to assess the interests of the public in the context of the facts of the specific case. Plaintiffs do not include authors, but the heirs, trusts, and estates of authors. Plaintiffs have not published illustrated children's books based on their novels and appear to have no intention of doing so. Thus, according to defendants, plaintiffs explicitly seek to stifle the creation of new works, and their sole interest in this case is not to preserve their own works or their ability to license their works, but instead to prevent the creation of new works. Plaintiffs' motives, they contend, do not satisfy the constitutional imperative that the limited monopoly granted to authors be exercised in such a way to promote the progress of science and the useful arts. However, the court cannot apply one fair use analysis where copyright holders can show they plan to exploit their works to make derivative works, and another fair use analysis in a case where copyright holders have not exploited such rights for half a century or longer. Such an approach would be inconsistent with the Copyright Act. Congress did not provide a use-it-or-lose-it mechanism for copyright protection. Instead, Congress granted a package of rights to copyright holders, including their exclusive right to exploit derivative works, regardless of whether copyright holders ever intended to exploit these derivative works. Indeed, the fact that any given author has decided not to exploit certain rights does not mean that others gain the right to exploit them, at least not until after the statutory copyright period, author's life plus 70 years. Implicit in defendants' argument, then, is a contention that the Copyright Act itself is unconstitutional. In sum, given the clearly infringing nature of defendants' guides and the fact that the guides are unauthorized derivative works that do not primarily critique or parody, but rather reproduce, albeit in different form, plaintiffs' original works of authorship, no reasonable trier of fact could find for defendants in this case. The court, therefore, grants summary judgment and orders the clerk to close the case, or close the motions, and grants all 9 counts of infringement, and rejects the affirmative defenses of fair use. Very interesting. So that's what it looks like when you try to use fair use to cover up otherwise infringing activity. What do we think of that? That was a very interesting case and well written by Judge Rakoff. Very interesting to read. It just sort of flowed. That's another reason why Judge Rakoff is a federal judge, is he knows what the heck he's doing.